Yes, Your Honor. At this time, the defense would move for a judgment of acquittal on a couple of grounds. One being that no trier of fact would be able to hear or at least deliberate on the evidence that's been placed before this jury for the following reasons. One, in regards to the 225-23 blood that was considered by the medical examiner in determining the cause of death. In that regard, the witness testified that, and when I'm speaking of the witness, I'm speaking of Dr. Methuen. Dr. Methuen testified that there was no way that she, well, I shouldn't say that she considered and had to rely on the summaries of the individuals who performed the test for litigation package.
What are you arguing about? Chain of custody?
No, Your Honor, the state, Smith v. Arizona, in regards, there was a surrogate witness that was placed on the stand. After her testimony, it was developed that she had to rely on the summaries of the individuals that actually performed the testing on that vial of blood for 225-23 and work order number 231-26889. That is the very vial of blood that the medical examiner relied on in determining the cause of death for Ms. Benning. Given the fact that the expert who testified to the validity, the integrity, and the blood in terms of the cocaine being in the blood, that she was a surrogate witness, it should be excluded after her testimony when she stated that in the amount of time that she had to review all of the data, she had to rely on the underlying test and analysis. Additional to that, she actually testified, I did not look at each quality control. I was not able to actually check each batch. With her not being able to do that, it violated Mr. Taylor's right to confront all of his witnesses and therefore violating the confrontation clause. As a result of that, anything that was relied on by that surrogate witness should be excluded and should not be considered. Without the blood listed in work toxicology report number 231-26889, there is nothing that the ME has testified to that she relied on in order to determine the cause of death for Ms. Benning. In addition to that, there has not been one witness that has come and tied Mr. Taylor to any drug, any form of cocaine whatsoever. There has not been any evidence presented to this court that Mr. Taylor bought cocaine, researched cocaine, did anything of the sort during the time.
Does there have to be?
We believe that there has to be a causal connection between Mr. Taylor and the cocaine in order to determine that he...
Just the proof based on who was in the apartment for the 3 minutes between the 911 call and the Ms. Benning's call, isn't it?
I would disagree in that it has not been established by any of the experts that the only period of time that Ms. Benning would have been required to take the cocaine, that it was only within that 3 minutes.
There's plenty of testimony that it would have been very quick.
However, they did not state that it would have been very quick after she took it, but we don't know when she took it, and we don't know who gave it to her. There hasn't been any evidence to
Somebody
suggest
in the
that.
apartment, or we, Danny, or, I mean, that's a jury question.
It is the defense position that no causal connection has been made between the cocaine and Mr. Taylor. As a result of that, in addition to the Smith v. Arizona issue, that there should be a judgment of acquittal, because without a cause of death, then there is no proof evidence that in fact Mr. Taylor could have caused the death of Ms. Benning. As a result of that, we move for a judgment of acquittal.
Okay. All right, does the State care to be heard?
Your Honor, Dr. Mithun was very thorough in explaining that she did her own analysis. She was not a substitute witness, just reading from someone else's report. She did her own analysis. She formed her own opinion. She wrote her own report. It is not even a comparison. Her explanation about that there's no connection to Mr. Taylor and the cocaine, the state submits that there is substantial circumstantial evidence of he is the person who put the cocaine in Jade Benning's drink. Her own words were that. She just didn't know what it was. Dr. Carney gave very explicit testimony about timing and that it wouldn't take long to feel the effects. She described dizziness as being something that would be possible, as well as the person might be able to walk, but not for very long after ingestion. And she said that a time frame of approximately 30 minutes until Jade Benning would be in full cardiac arrest, that was consistent with everything that she knew, and specifically consistent with the other autopsy she reviewed. That was the only one that had circumstances similar to Ms. Benning's case. There is I would say proof beyond an absolute certainty that Mr. Taylor was the only one with Ms. Benning in that apartment during that time frame. So the state would ask that their motion be denied.
Okay. All right, at this point, the court relies on the testimony that's been presented by the state. In light of that testimony, the court's discussed already the testimonial Smith v. Arizona issue. There's nothing the court's heard since that ruling that changes that. I mean, Dr. Mithun talked about each batch, but said that didn't affect her reliability of her testing. She looked at a number of them. I don't know if she was asked specifically how many, but, and in terms of the causal connection, something happened to Miss Benning in that apartment. There is circumstantial or direct proof that Mr. Taylor was the only one there, so that's not my role to judge credibility. If they believe Miss Jackson's statements, then the cited utterance from Miss Benning tells us who it was. So I'll overrule the motion for judgment of acquittal. And who is the defense first witness?
What type of James Smith, Your Honor?
James Smith. Is he here?
He is here, I understand. Really briefly, Your Honor, I think we need to test our computer system before we get the jury.
Oh, I thought that had already been done. The people were here.
I think we're here. I don't think we tested it yet. I just want to make sure we get it tested real quick.
Turn it on.
Is that your computer?
Yes,
What's on your computer?
it's a PowerPoint that's on
Well, your apps are down there.
yeah.
Your Honor, while they're sorting that out, the one other thing I think we're in a
See
better,
where Mark is. What
I
other thing?
think we're in a better position to have a discussion with Your Honor about the jury instruction, Your Honor, reference 4210A. It doesn't have to be right this minute, but at some point when Your Honor's ready, we can have that discussion.
Do you want it in the jury instructions or not?
At this point, I think our position is we don't necessarily want it in unless there were substantial revisions to it, which we can discuss, but I think as written, we do not want that.
Okay. Well, it wouldn't all come in. It'd be as to motive and intent.
The other concern I will point out, Your Honor, is the language of that jury instruction uses the word crime.
That's why I asked you if you wanted. It could say crime or other wrongful acts.
Our position would be the word crime should be taken out entirely because there is no proof. Of
I don't
crime.
know, that's what I said, whether the jury thinks discussing with someone else about facilitating or causing an abortion is a crime or not.
I think there's specific case law that that's not.
So you want it in there if it says other wrongful acts?
I mean,
What word do you want in there?
the closest I think we would, I mean, I think that was our position on this entire
So
form.
what do you want in there?
If Your Honor wanted to charge that, I think we would be comfortable with.
I don't want to charge anything, it's up to you. I'm required by law to put it.
We don't want it.
Okay.
That's our position. Thank you.
What Mark from it? But he was here.
Ethan, we don't need this for the first witness, so we could carry it to this meeting.
All right, get it, detective.